Hi, everyone. I'd like to welcome you to Cancer and Employment Law. This is a webinar sponsored by COCA with our good friend and pro bono attorney, Ariel DeFazio, who, as you can see, works at Lowrey, Parady, and Lebsack. Just want to say that, so besides being a compassionate, smart, and ardent advocate, Ariel also, she's just lent a hand on some, I don't know, yeoman's work for COCA. She has helped us with what I would consider hard to get through policies and stuff like that to make sure that we're in compliance. And she just lent a hand where she can, besides being there and always available to consult. So I guess I just wanted to number one, say that we're going to record this so that everybody can access it. And how this is going to go is that we will do the presentation and then leave some time at the end for Q&A. So Ariel, I'm just going to pass it on to you. Please do a better job of introducing yourself than my couple sentences.
Oh, well, it need not be lengthy, but thank you so much for having me. This has become sort of a tradition now where we seem to do it at least annually the last few years. And as Patrice said, I'm an attorney in Denver. I represent employees, many of whom have been either terminated from their jobs or who are, on their way out and are trying to navigate some real sticky situations. And that's often because of some protected class like their disability. Or race or sex, and et cetera. So this is certainly an area of passion for me. And in particular, disability discrimination, I think, is just one of those areas that's still not gotten as much light shed on it as, let's say, sex harassment with the Me Too movement. And this, I think, still remains an area where employers are, largely ignorant. Not all employers, but some are, even if they're very well-meaning. So it does give me a great amount of joy to pass this information on. And please, at the end of this presentation, my contact information is there. So if you have questions, don't hesitate to be in touch. But COCA is a very special organization, and I'm always honored to present to people who support it and who benefit from its many wonderful offerings. So the goal of the presentation today, whenever you're accessing it, whether it's today or some other future time, is to provide you, so individuals, who have cancer and their caregivers, with an understanding of what the legal landscape is for you. So what are your protections? What are the laws? And, not so that you can fully navigate those situations on your own, but so that you know enough to recognize what I would call red flags. So signs that your employer may not entirely understand their obligations under the law. And again, it may not be nefarious. It may be just, ignorance, or perhaps even, what I would call belligerent discrimination, where people kind of overly care about how you're doing and it becomes invasive or presumptuous with what you need or want. And it's not based on your actual capabilities. So that's my role, is to just help to develop your kind of radar for those sorts of red flags. So we'll talk about that starting from the time when you're diagnosed through your continued need for accommodations at work. So the relevant laws here are primarily the Americans with Disabilities Act. That's certainly the one that most people know about, or the ADA. There are two others that are at play, and they kind of depend on where you work. So for me, I work at an employer. My firm is only 5 people. So we're small. We're not even covered by the ADA. The ADA only covers workplaces that have 15 or more employees. Luckily, there's the Colorado Anti-Discrimination Act, which is a law that's obviously in Colorado only and covers all employers, including ones that are small. And then there's the Rehabilitation Act, which, if you're a federal employee, so you work for an agency like the Department of Labor or Department of Reclamation, it'll cover you. But I'll speak, about the ADA generally, and most of what I say is going to be relevant to both CADA and the Rehab Act. They mirror many of the provisions of the ADA. And the structure in all 3 of those laws is basically twofold. So on the one hand, your employer should not be treating you differently because of your disability. So they shouldn't be discriminating against you. They shouldn't be demoting you, failing to give you raises, failing to give you work because of your disability. And on the other side of that, they also have a affirmative obligation to accommodate you. So if you identify yourself as having something that falls within the definition of a disability, which we'll talk about, then they're obligated to give you reasonable accommodations and to have a conversation with you kind of on an ongoing basis to assess whether you have what you need. And that's just a really powerful tool that's not present in very many employment laws. Most of the time, there's just prohibitions. Hey, don't treat people differently, not an affirmative obligation to actually provide you with tools. And there's two really great resources that I'd recommend. One is the Job Accommodation Network, which is askjan.org. And that's a collaborative effort between the Department of Labor and a couple other entities. And it's a really great clearinghouse for sample templates and for letters for asking for an accommodation to your employer. There's a great series of brochures about different kinds of accommodations. So if you're looking for ideas, and they run through their ideas for accommodations based on the essential functions, so the job duty based on the disability. So there's actually a brochure that's all about, if you have cancer, what kinds of accommodations might be helpful for you. So I'd really recommend that. And I've even had clients in the past who maybe have a condition that an employer is not familiar with, just print out a brochure from the JAN website and give it to their employer. And it's kind of got everything they need in there. And also the Equal Employment Opportunity Commission, or EEOC, is the federal agency that is in charge of enforcing the ADA. And they've got some valuable information on disability discrimination and specifically on COVID. And they've kept that portion updated as this is obviously a moving target. So a few legal definitions. This is not terribly, interesting, amazing stuff, but the definitions are important because your coverage under the law really depends on whether you meet some of these definitions. And they, of course, have the, super attractive legal component where it seems like every definition has another legal term in it that needs to be defined. So it's like a chain. So the first one we'll start with is just, what is a disability under the law? And it's really quite broad. The definition is a physical or mental impairment that substantially limits one or more major life activities. That's a very onerous way of just saying it's basically a physical or mental condition that makes it difficult for you to do something that it's easier for other people to do. And that can be, just about anything: walking, talking, concentrating, taking care of yourself. They also include in the definition of major life activities the function of a body part or a body system. So certainly active normal cell growth is a function that's covered under a major life activity. So cancer is certainly hands down a disability, no questions asked. And that's the case even if it's in remission. If you still have cancer, if you have a record of cancer, then you're covered, you're protected by the ADA. If you're a qualified person with a disability, then you're protected under these laws. And again, that's, I'm speaking about the ADA, but if you work for a small employer, you're still going to be covered under these definitions. So if you're qualified, then you're a person who has a disability. So you fall within that definition. And then you can also perform the essential functions of your job with or without a reasonable accommodation. And so then what are the essential functions of a job? They're basically the central aspects of what you do. So what's in your job description? What do other people who've had your job done? How have those things changed over time? A court will kind of look through those different factors to try and figure out what the essential functions are. Certainly some of us have worked in jobs where there was no job description or it hadn't been updated in years, so they won't just stop at that part of the inquiry. But it's essentially, what do you do? And what things there's things that are essential and then things that are, ancillary to that. And then reasonable accommodations are just anything that's going to make it easier to do your job. And that can be structural things like, I need to, my start time to change. I need it to be a little bit later. I need to, get out of work a little bit earlier so I can go to appointments. To have one of your non-essential functions maybe distributed to somebody else. To have devices and equipment. So I have a client with a vision impairment, and so she benefits immensely from software that can actually read the screen to her so she can use a computer. So that those kinds of things are all accommodations. And an accommodation is considered reasonable as long as it doesn't impose an undue hardship on your employer. And an undue hardship has to be a significant difficulty or expense. So it's not just it's inconvenient or it's kind of expensive. It really has to be significant. So, I've had clients where, they requested something and an employer was hesitant because it would involve some expense, but that's just not enough to actually constitute an undue burden. So it's a pretty high burden for an employer to meet. So the first question I think a lot of people ask themselves when they're struggling with cancer, or they've just gotten a diagnosis, or maybe have been had a reoccurrence, is should I disclose my diagnosis to my employer? And it's a really tough question, and it's very much a catch-22 because on the one hand, I think people understandably are protective of that information because it's nothing that anybody has a right to know about unless you choose to disclose it. There can also be a component of vulnerability to disclosing that you have any kind of condition and that you might need something to help you do your job. So needing time off, needing, instructions in writing, just panoply of different, accommodations that can be helpful to you. But I think that people have a lot of pride around their work. They don't want to be perceived as needing anything or not being able to do their job. And sometimes folks, are working in an environment that's already kind of tense. Maybe there's a supervisor who's, already scrutinizing you quite a bit, and you're on the radar in a way you'd rather not be. So, having a condition like cancer and having to disclose that is very, it makes people quite nervous, understandably. The flip side of that is that if you don't disclose your condition and your need for accommodations, you won't be protected under the law. So your employer can't technically discriminate against you based on a disability that it doesn't know you have. And they also are not affirmatively obligated to accommodate you unless they know you have this. I think in each situation, you can be discreet about who you tell. If you want to just keep it with HR or just keep it with your supervisor, those are all options. But just know that there's going to be that give and take. If you don't disclose it, you can protect your privacy, but you're also not getting the benefit of the law. So, what should you do when you need an accommodation? The first step, in my mind, is to get your doctor on the same page. So if you have, an oncologist, somebody who's going to be, treating you, maybe even a GP, a general practitioner, a family doctor who's going to support you, make sure that you have them in kind of, ready to go, because for better or for worse, employers defer a lot to doctors, even though doctors are not vocational rehab specialists. They're not experts in, whether people can perform their job, but, for better or for worse, the law has kind of changed over time or evolved in such a way that, doctors do get a lot of deference. So if you can have a doctor who's going to support you, that's great. So if, you say, hey, Dr. So-and-so, I really just need a change in my schedule, and they're going to be supportive and say, sure, whatever you need, I'll sign it. Or yeah, that makes sense to me. Great. You've got somebody who, you should have on board. So let them know that you're going to be requesting accommodations. And there's even a handy brochure on the JAN website about kind of guidance for getting medical professionals to be helpful. And I think, I'm grossly overgeneralizing, but I think some physicians get a little nervous when there's any kind of legal ramifications to what they're doing. So I know of some doctors who won't, some of them are really hesitant to sign disability paperwork, really hesitant to sign anything coming from an employer because they just get nervous about, being involved in any sort of process that might be legal. So just whatever it takes to put their mind at ease, including, offering this guidance from JAN, I think is helpful. And then secondly, once you feel pretty good about that, then you can start the interactive process. And that involves communicating with your employer about what accommodations you think you need. So, throughout the process, you should be open, be honest, be prompt, don't let the ball drop. The interactive process is what it sounds like. It's two sides, it's ongoing. So it's not like you request, time off, your employer has accommodated you, we're done, no more accommodating required. That's not a process. The process is, hey, you might need something different down the road, or maybe you need more time, or maybe you need some help, with your tasks or some of your non-essential functions. Whatever it is, it's supposed to be an ongoing conversation between you and your employer. And my recommendation is to start in writing. Some employers will have a handbook where they actually give you a form to fill out if it's a pretty large employer and maybe a more sophisticated entity. You don't have to use that. I would if it exists. Most employers, I think, don't have anything like that. They just might have an ADA or an EEO, an equal employment opportunity policy that gives you a point of contact. Get in touch with this person if you need an accommodation. So just write an email to that person and include all these components. So in this slide here, I know it's a little dense, but there's just some basic information you want to give them. I was recently diagnosed. Here I have ovarian cancer. As a result, I'm a person with a disability. I'd like to meet with you to talk about possible accommodations. Here are some suggestions, a 2-week leave of absence for surgery, intermittent time off to go to chemo, the ability to work from home for the days after chemo when I feel terrible, and that you're open to discussing other ideas. I think you don't have to give quite as much information as I have here about your condition and the treatment you're going to get, but this is just an example. I'd say it kind of varies on the situation. It's always context dependent, but this Jan brochure is really helpful, and it gives you some guidance on how to go about writing an accommodation form letter. And it may be that you work somewhere where you're not worried about the scrutiny from an employer, and it's really just you sit down with your supervisor and say, here's the deal, and that's fine. There's nothing wrong with that. That's still requesting an accommodation. It's still engaging in the interactive process. This is really more for folks who are concerned about wanting to document it and just make sure you kind of get everything solidly in place. So a few examples of accommodations. There really is no limit to what an accommodation can be. It's anything, as I mentioned earlier, that makes it easier for you to do your job. But sky's the limit. I think it's really an opportunity for some creativity. So for instance, I've had clients who've gone through cancer treatments, and maybe initially they need time off so they can get surgery or chemo. They'd like, intermittent time to be able to work from home when they feel particularly rotten. And, as they've gotten treatment, then they've started to experience those really charming side effects like, brain fog, fatigue, the things that happen when you have chemo over time, and they want to keep working. And so they just need different things. So like I said about the interactive process, your needs might change over time. And as will the accommodations that you need. So there's kind of two general categories. There's reasonable accommodations, which are the kind you can get, and then there's unreasonable, which other people have tried to get, and just it's not going to go anywhere because under the law they've been found to be unreasonable. So things that are reasonable: a temporary part-time schedule. It's unreasonable to say I permanently want my position to go from full-time to part-time, but if it's, hey, I need a month or I need 2 weeks of being part-time, or you're gone for, maybe you're on leave for a month and you want to have a slow ramp up period where you come back, a few hours a day, and then you get back up to 8 hours a day by the second or third week. That's reasonable, certainly. Medical leave, working from home. That's especially the case now that, COVID's come and gone. Many people have worked from home and the sky has not fallen. So these arguments that used to come up earlier from employers about, hey, our productivity is going to go to, heck in a handbasket, is you're just really not going to be as supportable now that entire classes of people have been working from home for years. Certain unreasonable things, in indefinite leave of absence, it really does help. That's where there's tie-in with having your doctor on board. They're making their best guess if you're getting treatment, or if you have an injury or something. They're really just making their best guess as to when you can come back. But if you're looking at a return to work date that's more than a few months ahead of the time that you're taking off, that can become problematic because there's cases, there's law, there's judges that have decided your employer doesn't have to hang on to your job for you. That's unreasonable to request them to do so. So it's fine to take off time. It becomes unreasonable the longer that period of time is, and the less certainty there is with which you'll be able to come back at a certain point. Asking for any kind of misconduct to be excused. So if there's absentee issues, which is, really one of the reasons why I think that disclosing a disability and asking for accommodations early on can be helpful, because you try and get in front of an argument like that. So if if you've gotten treatment and you're sick and you're not able to come into work for several days in a row, instead of, coming back and getting a write-up, that then you have to say, hey, wait a minute, I actually have X, and, I have a disability, I need an accommodation. you can have gotten in front of that and putting them on notice that maybe you were going to be struggling and not able to come in. So it's better to, I know they say it's better to ask for forgiveness than permission, but this really is the opposite in this case. So these are just a few examples of accommodations. And like I said, there's an opportunity to be creative in what you ask for. There may be some instances where once you've requested the accommodation, your employer will come back to you and say, well, that's fine, but we need a little more information. And generally that's okay. I know some, people get nervous about, digging into your medical records and such, and I get that. And there are some limits to it, but it is okay for your employer to ask, about something general like your well-being. How are you? How are you feeling? And asking for accommodations or asking for documentation to substantiate that you really do have a disability and that you need accommodations. That's really as far as it should go. They should not be asking for, specifics. What meds are you on? What treatment are you getting? Unless you have a relationship where that makes sense in context with an employer, they shouldn't be getting into those kind of details. And they certainly shouldn't be asking for, I want to see your medical records. I want to talk to your doctor. I mean, any of that stuff is then getting into the red flag territory of why do you need that much information? All they really have a right to do is just to confirm, yes, they have cancer and yes, they need some time off, and that's it. And there's some guidance here at the bottom of the PowerPoint about a website you can go to for the EEOC that talks a little bit about some of these inquiries and what's okay and what's not. So some red flags at this point. So you've disclosed your cancer, you've started the interactive process. Any comments about your ability to do your job, and based whether that's on assumptions or stereotypes, benevolent or not. And I mean that in the sense of, somebody, maybe a supervisor, is very caring, really worried about you sincerely, and thinks, maybe you should just go on, you should just go on leave, don't work, you really need to rest, or you need to recover, or spend your energy on getting better. And that's fine, but it needs to be your decision. What it comes down to under the law is that, you need to be judged, workers need to be judged by their own capabilities and what their doctors recommend. So if your doctor thinks you can work while you're getting cancer treatment and you want to work during that time, you should be able to. If your doctor's saying, you really shouldn't, that's one thing. But again, if you've got a doctor who's going to support you and thinks you can do it, and will support no matter what you want to do, then you do you, and your employer should not be questioning that and making it seem like you're stretching yourself and you should really be at home resting and recovering. It's about what you can do and what you've been cleared to do. Different reactions to men and women, to their medical conditions and requests for accommodation. Every once in a while you have situations where a woman with ovarian cancer may be treated differently than a man with prostate cancer. That can indicate sex discrimination more than anything. It's a little unusual, but it definitely happens. And then requesting excessive amounts of information about your condition, asking you to sign a blanket release to see your medical records. Any of that is just too intrusive, and there's just no need for that kind of information. Other ones, pushing back on your doctor's recommendation. So this can be kind of tied in with thinking they know what's best for you. Well, your doctor says you can work, but I really don't think you can do this job while you're getting cancer treatment. My mom had cancer, she couldn't work and whatever. That's fine. People want to be helpful and offer their anecdotal experiences, but it's not okay if they're limiting your ability to work and you really do think you can, and your doctor supports that. Refusing to provide you with reasonable accommodations, even though they're clearly not going to pose an undue hardship. And again, that's a significant difficulty. So we're talking about, considering the company's finances, if this is a big company, is it really going to matter that you request an ergonomic chair that's, a few $100s? Probably not. And note that your employer can offer you alternative accommodations. So if you request something and they can't do it for whatever reason, they can say, well, we can't give you this, but we can give you this. And that is potentially okay, as long as it's going to fulfill your needs. So once you're getting treatment, has your need for accommodation changed? And I mentioned this earlier, that once you start to get treatment, you will likely experience symptoms that will make it so that you need help in different ways. There's a great brochure that I refer to here from the JAN website about cancer and the kinds of accommodations that you may want to request that may be helpful for you. And it really just depends on what your symptoms are. If you have decreased stamina, if you're fatigued, you may need a flexible schedule. You may need the ability to work from home so you can rest. It's easier to be able to kind of work in spurts and then nap and whatever when you're at home as opposed to the office. If you're having trouble with executive functioning, so you just can't seem to remember stuff very well, or if you don't write it down, it's gone, then you can request instructions in writing. So every time you have a meeting with your boss, you can request, hey, can you just write a quick email to me requesting or putting in what we discussed. That's fine. Or maybe you can do that and request an accommodation where you summarize your discussion, you send it to your manager, and then they say, yes, that's accurate, or no, it's not. Here's why. If you have a suppressed immune system, this is obviously particularly relevant now, although I certainly hope that COVID is becoming less and less relevant. But if you are still really nervous about working in person because you have a suppressed immune system and there's still COVID in our environment, the ability to work from home is certainly an accommodation to request if you can do the essential functions of your job from home. And these are just a few options, but continue the interactive process. You can do the same thing you did when you started it. You can sit down with your supervisor. You can write another letter saying, hey, my needs have changed. I need to re-engage in the interactive process with you, but just know that it's ongoing and you have the right to start it up again whenever you need to. And your employer is not off the hook just because they did okay the first round. Things change, your needs change, and that's okay. Under the law, you're entitled to ongoing accommodations. And it may be that you get to a point where you may not be able to keep working. And that's obviously a decision you have to make with your physician, and it's not going to involve your employer at all. But there's a couple questions to ask yourself. Can you really keep doing your job? If not, is there a vacant position that maybe you could work in temporarily? That is also an accommodation. So a transfer to a vacant position, even if it's temporary. And it may be that, if none of the above, then taking a leave of absence is appropriate. And you can, do that under the ADA in another, now I'm forgetting when it's going to start happening, but in another year or two, we're going to have paid family leave in Colorado, because right now if your employer is large enough, you've got the ability to take leave under the Family Medical Leave Act that's protected in the sense that you can't be fired while you're on leave. It's not paid. So we're actually going to have paid leave, which passed in a ballot measure a couple of Novembers ago. So that's really great news. It's just being implemented now. And I'm not quite, I think the rollout is 2023, but I'm just not sure. So before that time, it may be that you have to take unpaid leave, or you may have to take leave where you're exhausting your vacation. Your employer is allowed to do that, to have you use your vacation or your sick time, and that can run along with your FMLA leave if you take that. Something that a lot of people don't realize is that FMLA or FMLA leave doesn't apply if you work for an employer that's smaller than 50 employees within a 75-mile radius, and that excludes a good number of employers, certainly mine included, and many I've worked for in the last few years. So if you don't have family medical leave, fear not, you can still ask for an accommodation for a leave of absence under just the ADA, but it doesn't include the same level of protection that FMLA leave has. And of course, there's a concern of if you're taking unpaid leave, how are you going to get paid while you're gone? And the answer to that, if we're still not in the realm of having paid leave under Colorado law, which even then is not going to be 100% of your paid leave or 100% of your replacement of your wages. Sometimes people will have short-term disability insurance that they've paid for through their employer or privately. And that requires that you can't do your job. And there can sometimes be a fight around whether you're entitled to it. And that's unfortunate to have that fight while you're on leave with cancer treatment. It does happen sometimes, but I would certainly hope it wouldn't. But that typically pays anywhere from 40 to 60% of your salary. There's also Social Security disability insurance, which is, I think, virtually automatic if you have certain diagnoses. I haven't looked at it recently, but within sort of the cancer realm, there's several of them that would qualify you. And otherwise, you have to apply it and wait sometimes 3 to 5 months for a decision. And that requires that you can't do any job at all and not just your current job. So the ability to get pay using short-term disability insurance is certainly more generous than SSDI. So in this realm, you've disclosed your condition, you've gotten some initial accommodations, you're still getting treatment, maybe you're having experiencing some other symptoms, and so you're following up with your employer to get additional or different accommodations. Here are some of the red flags to look out for. Certainly all of the above, so everything I already talked about, plus insisting that you go on leave. So if your employer is starting to put more pressure on you to be home, to not be working, I don't think you can do this job, and you don't think that's true, then that's problematic. Sometimes there are situations where you really do, you may not be able to work, and folks may be in somewhat denial about that. But, I think a lot of times people have a good understanding of what they're capable of, and their doctor will be honest with them about, you really should stop working, or I think you're doing fine. Pushing back on your doctor's recommendations, especially when it comes to, your doctor saying, yeah, you can go back to work now, and then your employer won't let you. That's a problem. And expressing irritation with just, gosh, you're needy. You have a lot of stuff that you keep asking us for. That's annoying. Well, okay, maybe, but under the law, you're entitled to it. So don't hesitate to take advantage of it because it's something you're entitled to. In the future, if, hopefully you've got treatment, you're in remission, there certainly are instances where there can be a recurrence. How do you know if there's red flags kind of arising from that? Keep in mind that even if your cancer is treated, it's in remission, you can still, if it does come back, you can continue along the same path of requesting reasonable accommodations, and that you're protected by the ADA under that. Even if it never recurs, you still are protected by virtue of the fact that you have a history of a disability. So, a kind of classic example of this is if you're going for a job interview and happen to disclose that you had, cancer 5 years ago, and then you don't get hired because there's a concern about, well, what if it reoccurs, and then they need treatment and it's expensive and it'll make all of our health plans more expensive. I mean, it's a little ridiculous, but it does happen. You are protected from discrimination on that basis, because that is discriminating against you based on your record of having a disability, even if it's not active at that moment. And that's why, I think some people are very hesitant about disclosing a previous diagnosis when they're in the hiring process for a new job. And I understand why, because there can be stereotypes and assumptions that are made about somebody's availability to work and kind of staying power because of a health condition, which is unfair and illegal. And then if you experience a recurrence, just start the interactive process again. And regardless if it's the same employer, a new one, their obligation to accommodate you never ends. It's just the gift that keeps on giving. Other red flags, everything I've talked about. Plus, keep an eye out for if you've been at an employer for a while, are things changing in the way you're being treated? So are you being taken off of projects that are, lucrative or high visibility or, desirable? Are you being paid less than other people? Are you not being promoted? Are you suddenly seeing, reviews, annual performance reviews that have negative material in them, and you've never received that kind of feedback before? Those kinds of changes are, definitely evident. And I've had many clients who've experienced them where they seem to be going just fine and sailing along, and they're a great employee and they're very well liked by a manager, and then they disclose a disability and a need to be out or to get some other kind of accommodation, and the manager just turns on them and they are scrutinizing their every move and giving them low ratings, and it's pretty evident at what point that changed and why. Certainly expressing concern that you pose a liability to the company because of your condition, because it'll make premiums expensive, because what if you get sick, and who's going to do your work and all that stuff. Yeah, I understand that that's part of running a business, but it's also not a legitimate concern, and certainly not one that they should be raising in your presence. So there's also protections for caregivers. So if there's somebody who brings you to appointments, goes to your house and helps when you come out of chemo and feel like garbage, you have legal rights too. If you are within a certain kind of class of family member, you can take leave under the Family Medical Leave Act to care for a biological, adopted, or foster child, a spouse, a parent, but not in-laws. That is a wonderful change with this new family medical leave law under Colorado law is that that definition of family member is now much broader. So it includes in-laws, it includes grandparents, it includes people who are considered, like who you consider to be family, siblings. So it's a really wonderful change, among other things. And then there's a real phenomenon too, where you could be the recipient of association discrimination, which is if you have an association with a person with a disability that your employer sees and perceives as a liability. Like, oh man, they have a kid who with special needs and needs to go to the doctor all the time. That's going to be way too much time away from work. Let's not take them. They're going to call out all the time. That is a kind of discrimination based on disability as well that is you're protected from under the ADA. But just note that this is kind of a nuance, but that you don't have a right to reasonable accommodations for somebody with whom you're associated. So if you have a loved one who needs to go to medical appointments, you don't have the same right to request reasonable accommodations for them kind of on their behalf. That's only for yourself. There's also the concept of caregivers' rights, which is under Title VII of the Civil Rights Act of 1964. There can be stereotypes where disability discrimination and kind of sex discrimination are if they were two Venn diagrams, this is the spot where they overlap. So women still, even after all this time, are still perceived as less committed to their jobs, less reliable, less competent than their counterparts if they have caregiving responsibilities. And this can be women with children. This can be women with, let's say elderly parents who they're caring for. And then, on the counter side, there's, men who have caregiving responsibilities are seen as anomalous. Why would you possibly have to take care of somebody when you have, when there are women in your sphere who can be doing that? So those stereotypes are extremely antiquated. But they still persist. So I would, keep an eye out for them, because certainly if you see men and women being treated differently for any of these reasons, then that's concerning. Other red flags for caregivers, comments about your commitment to or ability to do your job based on assumptions or stereotypes. And again, benevolent or not. So, hey, your wife has cancer, just take leave. You shouldn't even be working. You should be with her. Okay, well, that's, again, nice thinking, but is that what you want? Is that what the employee wants? Is that really necessary? Or is that the presumption from an employer kind of putting their stereotypes on the person rather than getting an understanding of what that person can do and wants to do? And then seeing how you're treated differently from colleagues. So do you have a colleague who wants to leave early to go to a kid's baseball game, but then if you want to leave early to bring, a spouse to a doctor's appointment, all of a sudden, you're not approved for that time off. That's notable. And it may not seem obvious, but we call that circumstantial evidence. And it looks like, oh, well, you're treating people who are similarly situated to me differently. And the difference is the reason why we need that leave. And that's notable and certainly a red flag. So what do you do if you ever see any of these red flags, which I hope you won't? First of all, just keep documentation of it. What was said, to whom, by whom, lots and lots of stuff's in emails now or texts or Slack messages. So just keep that stuff. Don't go crazy with keeping copies of these things, but, make a note of, he said this to me on this date. This is where we were. This is the time. Your memory will only deteriorate over time, because all of ours do. So just keep a running kind of log of that. Check your employee handbook to see if there's procedures about discrimination or harassment or reasonable accommodation complaints, and assess whether it is you want to, it's reached a point where you think you should file one of those. I'd say before you do that, you may want to contact an attorney, contact Jan. They, in addition to having such wonderful resources on their website, they also provide free technical assistance. So you can literally call them, talk to somebody who has, pretty phenomenal expertise in the ADA and ask their advice. I don't think it's not legal advice. I don't believe they're attorneys, but they have some really good thoughts on kind of how to navigate these situations. And certainly call me if you have questions. I'm happy to talk to you. If you feel like, what happened to me, I was terminated, I was demoted, I was denied a raise or something, and I'm quite certain that it's because of, either my disability, a loved one's disability, or my need to take care of that person, then you can, the next step beyond these initial steps of, contacting an attorney and JAM is that you need to file a charge of discrimination with one of these agencies, either the EEOC or the Colorado Civil Rights Division. It doesn't really matter which one unless you're at a small employer. So if you're not even covered under the ADA because your employer has 14 or fewer employees, then you must file with the Colorado Civil Rights Division, and you only have 6 months to do that. So that comes and goes pretty quick. The EEOC have 300 days, so you've got a little bit more breathing room. And that's just a required step before you can ever go to a lawsuit. And that's not normally where people even want to go. Most folks just want to be able to work and they just want to be left alone. But sometimes it's just helpful to know what the road is. So in case you have to go that route or begin the process, you know what the next steps look like. So this is my contact information. Again, I'm always happy to answer questions. Any friend of Coca's is a friend of mine, so don't hesitate to reach out. And I'm happy to answer questions if anyone has any.
Ariel,
Yes, please.
this is Kathy, and I so appreciate your time today, and this is such valuable information. I had an